accordance with the Bail Reform Act of 1984, the ROR should be granted unless the court could unequivocally prove that there's some question as to the ability of the or intent of the defendant to return. The burden is on the court to substantiate some sort of
People's position on that.
Your Honor, I don't know that much has changed since the last time that we were in court, except that we've learned that Mr. Zavalidroga has been less than candid about his status with respect to ownership of property. We found out that he was somewhat disingenuous to the court about that aspect.
I would like to interject.
Obviously, the test is whether or not he will return to court and whether or not he will commit a crime if released. And I think the last time we addressed this issue, the fear was that he would attempt to contact the victim in this case, and that it was his own words that condemned him in that respect. So there's still that fear that exists that he'll attempt to contact the victim in this case and attempt to influence her, and that because of his dishonesty with respect to a simple application for services for the public defender, being dishonest about that, there's no real guarantee that he would return to court on the return date. So given those two factors, we'd ask that the bail be continued.
I'd like to address that.
You wish.
Yes. As far as the property, I initially stated that there was there was sort of an ongoing situation with the property, and that I had no knowledge of my name on an actual deed. I've never received deeds on property. That's the only information I granted to the court, but was forthright in indicating that there was an ongoing negotiation. I've never attempted to contact the witness in this case. It's also up to the court. The burden is on the court to establish some evidence of.
All right, I understand what you're saying.
And we also know that he has no prior criminal record.
Also, I do have some prior background in positions of trust in the community as a part-time school teacher some years ago. In fact, it was right here in Oneida.
Here's the defendant just continues to be dishonest about his situation, Judge. He indicated that he was unaware that his name was on any deed, when in fact it was him that signed the quitclaim deeds that transferred the property into his name, as he did it through a power of attorney that he had to his mother. So for him to continue to try to deceive the court in that respect only, I think, shows the